Dear students, I am Mr. Rajahan, lecturer, Department of Law, World University of Bangladesh, and this is my class lecture on the topics of Section 13, 14, 15 of the ICT Act 2006. In an electronic environment, it will be important to authenticate the identity of the sender or the originator or the person who sent on behalf of originator of an electronic communication or electronic record or message. Section 13 of the ICT Act 2006 deal with various security measures that may be adopted effectively to authenticate a person's identity or to determine the originator of an electronic record. In this context of electronic contract formation, it will also be important to ensure that a party who purport to enter into a contractual relationship by electronic communication is authorized to enter into that contract. So this issue is covered by Section 13 of the ICT Act. Subsection 1 and 2 of the Section 13, it's determine of the originator of an electronic record. An originator is one who originates an electronic record. On the other hand, an addressee is one to whom an electronic record is sent or who acknowledges or received an electronic record. In case of online transaction or communication, it is required to be sure that the electronic record has been sent by the originator in the electronic record. To be sure who is the originator of electronic record and who sent the electronic record contained procedure have been mentioned in Section 13. Now, the second thing is, when does an addressee treat an electronic record as that of the originator? This is stated in subsection 3. In an electronic communication process or electronic transmission, it is required for an addressee to be sure that the electronic record sent to him is sent by the originator or by any other person authorized by him, and then act for the purposes for which the electronic record is sent. So, subsection 3 describes the circumstances when the addressee shall treat an electronic record as that of the originator and act on the assumption that the electronic record are that of the originator. So, as between the originator and the addressee, an addressee shall be entitled to regard an electronic record to the originator and shall act on that assumption if, number 1, the addressee properly applied a procedure previously agreed to by the originator in order to ascertain whether the electronic record was that of the originator. Number 2, the information is received by the addressee resulted from the action of person whose relationship with the originator or with any agent of the originator enable that person to gain access to a method used by the originator to identify the electronic record as its own. Now, subsection 4. When does an addressee treat an electronic record as that of the originator? Subsection 4 of Section 30, this specifies that the addressee shall not treat an electronic record as that of the originator. Number 1, from the time when the addressee has received notice from the originator that the electronic record is not that of the originator and has reasonable time to act accordingly. Number 2, when the addressee received information from a person whose relationship with the originator or with any agent of the originator enables that person to gain access to a method used by the originator to identify the electronic record as its own. In such a case, the addressee shall not treat an electronic record as that of the originator. Now, the addressee shall not treat an electronic as that of the originator if all the circumstances of the case it is unconscionable for the addressee to regard the electronic record as being that of the originator or the act of the assumption. Now, subsection 5. This is the presumption of intention of originator relating to electronic record. Receiving the electronic record, the addressee shall presume that the originator has sent the electronic record for what the originator intended to send, and the addressee shall act on that presumption. So, between the originator and the addressee shall be entitled to regard that the electronic record received as being what the originator intended to send and act on that presumption, where an electronic record is that of the originator and is deemed to be that the originator or the addressee is entitled to act on that presumption. Section 40. Acknowledgement of receipt. Now, acknowledgement means accept, admit, recognize something, or to exercise of existence of something. So, acknowledgement of electronic record means to accept, admit, or recognize electronic record when such electronic record are dispatched or sent to a person. So, the electronic communication or electronic transmission in computer system, computer network refers to the dispatch of electronic record by one party and the acknowledgement of electronic record by another party. So, acknowledgement of receipt plays a very important role. So, now the modes of acknowledgement. When number 1, when agreed. Number 2, when not agreed. Number 3, conditional acknowledgement of receipt. And number 4, unconditional acknowledgement of receipt. Now, when agreed, where the originator has agreed with the addressee the mode of acknowledgement on or before the sending electronic record. This means that the originator may request or agree with the addressee that the receipt of the electronic record shall be treated as acknowledgement of receipt. In short, if the originator agrees with the addressee that when an electronic record that has been sent to him is received by him, such receipt will be treated as acknowledgement of receipt. It is based on the assumption that the acknowledgement procedure are to be used at the discretion of the originator, because only the originator can offer the addressee to be agreed relating to the acknowledgement of receipt. Such mode of acknowledgement shall be applicable if the originator agrees with the addressee. Number 2, when not agreed. Now, when not agreed with the addressee that the acknowledgement of receipt of electronic record not given in a particular form or by a particular method, in that case, an acknowledgement may be given either by any communication by the addressee, automated or otherwise. Number 2, any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received. Now, number 3, conditional acknowledgement of receipt. Where the originator has stipulated that the electronic record shall be conditional, binding on the receipt of acknowledgement, then until the acknowledgement has been received, the electronic record shall be deemed to have never been sent by the originator. So, the acknowledgement of receipt is a condition for this type of contract or agreement. Number 4, unconditional acknowledgement, that is not binding. When the acknowledgement of receipt shall be unconditional, where the originator has not stipulated that the electronic record shall be conditional on the receipt of this acknowledgement. Subsection 5 and 6, that refers presumption as to the electronic record and technical requirement. What is that? Where the originator received the addressee's acknowledgement of receipt, it shall be presumed that the related electronic record was received by the addressee, but that presumption shall not imply that the content of the electronic record corresponds to the content of the record received. And subsection 6, where it's received, the acknowledgement stated that the electronic record meet technical requirement either agreed upon or set forth in applicable standard, it shall be presumed that those requirements have been met. Section 15, time, place of dispatch and receipt of electronic record. Now, what is dispatch of electronic record? Dispatch means to send something, especially goods or message, somewhere to a particular purpose. So dispatch of electronic records means to send electronic record to somewhere or someone for a particular purpose. Now, what is time and place of electronic contract? When a construction contract has been formed when a change of electronic communication, such as the email, there are legal undertakings that make it difficult to determine the precise point in time at which the contract has been formed. This reason it may be important to determine the time of contract formation that once an offer to enter into a contract has been accepted become irrevocable. So, until the point in time in which the offer has been accepted, the offerer is free to withdraw the offer. In this context, electronic communication, the legal rules that govern the time of acceptance of an offer are unclear. Under general law, contractual principle, the general rule is that the acceptance of an offer is effective at the time it is communicated to the offerer. In the case of determining the time and place of electronic contract, it is required to determine the time of dispatch, time of receipt, place of dispatch, place of receipt of an electronic record. So, the time, like company A wishes to enter into a contract with company B on Friday, 8 June 7 a.m. sent an email to B offering to enter into a contract with B on the term attached to the email. The email entered to B's computer or resource at 7:10. The time of dispatch of the email is 7:10 a.m. Okay. Now, subsection 2. The time and receipt of electronic record. So the determination of time of receipt of an electronic record is considered whether the addressee is designated or not an electronic device or resources for the purpose of receiving electronic record. If the addressee has designated an electronic device or resources for the purpose of receiving electronic record, received occurs at the time when the electronic record entered the designated device or resources. Place, how it's going to be determined. Like Zohir is a businessman operating from his business in Dhaka. So he sent an order to email to a company having its head office in London. So the place of dispatch of the order would be Zohir office in Dhaka, and the place of receipt of the order would be the company's office in London. Right. Subscribe and hit the bell icon, and don't forget to give a like.